Hello. Good evening, everybody. Today in the lecture series, in the MBA in collaboration with the Tamil Nadu Senior Advocates Forum, the topic is the art of advocacy, and the speaker is Mr.A.L.Somayaji, former Advocate General and the Senior Advocate. The art of advocacy, there are many different types of advocacy, each with its own strength and weaknesses. Advocacy is a noble art. Advocacy is an honorable art. Advocacy is an endless quest in the honing of persuasive reasoning skills, and the art of advocacy is as potent and diverse as imagination. Thank you. The art of advocacy cannot unravel the knot of human fate, but it can inspire, uplift, and empower the wings of thought and harness the heat of the mind, colored brightly with the blended energies of human passion and emotion, enriched and informed by our social modes. The art of advocacy is innocent of vice, is empty of wrong, is but a path of enlightenment, yet only to the heart of pure of heart. So far as the art of advocacy is concerned, I can say the basic principle of art of advocacy is getting adjournment in the court. My senior, Mr. Gandhi, used to say, once an advocate gets the art of getting adjournment before the court, it goes without saying that he has learned the art of advocacy. And now I feel, nowadays I come across so many younger advocates who are not only getting adjournment and also get the interim order extended. With these few words, I pass the mic to the speaker.
Good evening to all of you. Art of advocacy is the subject matter of my talk today. I don't know how competent I am to speak about it. However, what little I have learned, I want to share with you. Along with what I have seen, the best of advocacy in this court. The president of our association said, art of advocacy lies in adjournment. I think it's not working. I think it is part of art of advocacy. To get an adjournment is also part of an advocacy. The advocacy assumes more importance on account of certain peculiar features of this legal profession. When we inquire about a cardiologist, somebody gives you the name, you go to him. We do not know anything. By mere word of reputation, we go to the doctor. But in the case of advocate, it is totally different. There is a central place called court hall, which is a public place in which judges are there, lawyers are there, clients are there, the opponent side of your party is there, his advocate is there. Apart from that, we find so many pro bono. So you are not only judged by the judge, but also by all those who are present there. So each one, the client knows his case best, and he knows how best you have presented his case. Unlike a doctor whose mere reputation is by word of mouth. Therefore, I think it is very necessary for a lawyer to develop the art of advocacy. Art of advocacy cannot be taught to you by reading a book. It is by experience you get it. And if you work in a good office, you learn so many techniques of the art. And a few people are privileged. Few people belonging to my generation are more privileged. Next generation less privileged. Nowadays there is no need to go to any office. The day you enroll, you come to court. And therefore, the importance of the art of advocacy cannot be undermined. It is one of the most important armory in the advocacy of a lawyer. If you say mere advocate, that is not enough. If you do not learn the art of advocacy, a best case can be presented in a bad way and you lose the case. Therefore, it is all the more necessary for you to learn this art of advocacy by observing your senior and other people who argue in court. I can give you one illustration. All of you must be knowing Mr. Siddharth Shankar Ray, late Siddharth Shankar Ray. He was the governor of Punjab and Haryana. He was the Chief Minister of West Bengal, and he was practicing in Supreme Court. He came here for a case relating to our cricket club, and at that time I was with the government as Additional Advocate General. He came to my chamber. It was listed before Justice Ibrahim Kalikula. Now that he is retired, I can tell him. And he asked me what is the item number. I told him it is 120, sir. It is not likely to reach today. And he said, what should I do? I will sit down here for some time. He sat down. After about an hour, he said, no, let us go to court. I said, no, sir, there is no point in going there because the case is not going to reach today. It won't be taken up. He said, no, we have to go. So I followed him. I was appearing for another party. He was appearing for another party. No doubt both of us are sailing together. Then he went and sat in court. The judge asked him, Mr. Ray, for which case you are waiting? He said, my case is 119. And Justice Kalikula told him, no, it's not likely to reach, sir. We need not wait. Then he got up and said that I am told that it won't reach. In spite of that, I want to be present here. And if you will permit me to digress, I will tell you what happened what experience I got. Then he narrated in those days, when in the days of Mr. Ray, the enrollment used to take before the first court. As per the practice, the Chief Justice will, after the enrollment, give a short lecture. And he mentioned the name of one of the English judges, I don't remember the name. He said that Chief Justice told us, myself, he said two other persons were enrolled on that day. After the enrollment, he told us that in order to be successful in the legal profession, you need not learn all law. But if a problem comes, you must know where to lay your hand, number one. Number two, you must observe the judge. Number three, you must know the judge. He didn't mean that knowing him personally. You must know how he behaves, which appeals to him, which does not appeal to him. And therefore I sat in the court. That is what Mr. Ray said. It's a very part of advocacy to observe the judge and what is to his liking, what he doesn't like. That is one instance. Another instance which I read in the centenary book is, it seems a case was listed before Justice Somayaji and Parker, Justice Parker. the case was fixed for hearing, and the judges said they fixed 3 weeks for hearing the matter. The counsel also agreed at the time when the date was fixed, and he came to the court. And the judges said that on the day they assembled, Mr. appeared in the matter. He said, my client is dead today. Then Mr.A.L.Somayaji got a little bit upset. He said, we have read for so many days. What is this? For the entire 3 weeks you have allotted for your case. Then it seems the lawyer remarked, my client did not inform me that I was going to die, number one. Had he informed me, consulted me, I would have told him to postpone the death by 3 weeks. And the court, everybody laughed and said, this is part of the advocacy. Instead of that, you could have been very rough and said, no, how can you say when the party is dead? So there are different kinds of advocacy, as pointed out by our president. Some, I don't know whether you have heard of mendicant advocacy. They only beg for some order. Some people are rebellious. That also we have seen. But both the things are not good. We must adopt a middle path and do work. From my point of view, I had an experience. A client came and engaged me when I was part of Ireland to argue a sales tax matter. Number of matters were listed, so I thought there was no difficulty. On that particular day, unfortunately for me, the portfolio judge went on leave, and it was listed before Justice Mohan. And he created a hell for me, and he said, no, I'm not going to admit. Then I told him, Your Lordship has admitted number of matters have been admitted on the same point. Then he told me, no, that is not a point for admission. Then for some time I hesitated and I told him, my client has to blame himself for engaging an incompetent advocate. Then he said, no, I will give a certificate to you. I just got to the point of giving the certificate. I can only keep it in my office. But that won't help me in any way. Then he laughed away and admitted. I am saying it happens that way. Similarly, I had an experience when I was part of Ireland. A trade union leader came to me and he wanted me to intervene in binding a petition. Binding a petition, trade union, I thought, why trade union has got no role in the binding a petition? It's only between the debtor and creditor, debtor company and the creditors. That man insisted. Then I understood that there is somebody behind him. Then I told him, if somebody, you are fighting for somebody, then I would like to meet that person concerned. He came to me, and the employer was behind it. He came to me, and I said, I will fight for you. But this is a dicey proposition. There is no provision in the Companies Act for a trade union or the workman to intervene. Anyway, we will try. I filed a petition for impleading in the binding a petition, supporting the debtor company. It came before a single judge. He dismissed it. Then it went before a division bench. I stood up. I think, I don't want to mention the name of the judge. He said, there is somebody behind you. I said, no, nobody is behind me. It's my shadow that you see. But really, he guessed correctly. Then they also dismissed it. Then the matter went before Supreme Court. It is interesting there. The question arose, they asked, what is this? I said, if a worker whose life and livelihood is involved in the industry or the institution or establishment, he must have the right to say something on the continuance of the establishment. When such a right is given to a creditor for 500 rupees, worth of 500 rupees, he can issue a notice for non-payment or default in payment and file a binding a petition. It came before Justice Bhagavati and Venkatramayya. Justice Bhagavati felt that there is some point. He said no, but Venkatramayya was not all right. He said no, this matter requires 3 judges. Then 3 judges benches came. That addition was Justice one gentleman from Kashmir, one judge. He was added. The Bhagavati was not very certain as to which side he will fall. So he felt, no, next hearing the matter came, he said, no, it's a very important constitutional question. So it has to be put to constitutional bench. So it came before a constitutional bench consisted of these 3 plus Chinnapalli and somebody else. So they heard it. And they finally decided the trade union has got a right to intervene in a binding application. Why I am mentioning this is it's not as if we have to reject all cases. If we have to raise a new legal ground, acceptable legal ground, at least a possible legal ground, therefore that is also a part of the advocacy of a lawyer. And in another case I argued against MRN. I am telling you why you should not be very rough and tough with the court. The question arose whether who is in possession, civil matter, who is in possession of the property. Mr. Late Narayanasamy said, my client was in possession. I said, my client is in possession. Then the bench said, no, we believe Mr. Narayanasamy. At the time my blood was young. So I immediately retorted and said, no, why do you say that you believe Narayanasamy alone? Both of us take instructions from our respective clients. So if whether my client is true or his client is true, you can't go by the eminence of the lawyer. I lost the case. Whereas today I won't do that. I know how to tackle that situation. I am saying what you should not do. So it is a very, this profession is really very tough profession in that sense. And since there is nobody to teach you this, you have to learn only by your experience and by watching seniors. In fact, in one instance, I was sitting in court. Mr. Govindasanand was also sitting in court. There is a matter listed, the judge was harassing the lawyer. And he stood up and said, you can't harass him. Mr. Govindasanand stood up and said, you can't harass him like that. And there were, doyens at the bar. And it is really from their way of addressing the court. Maybe at times the bench is not fully in agreement with what you say. But there is no point in being belligerent and fighting with the judge. That is not going to take anything. It will only worsen the situation. Instead of that, it is better to convince the judge by appealing to his good sense. I don't say you should beg. That is not necessary. There is no need for you to beg for the sake of the client. But appealing to the judge and trying to convince is the best form of advocacy. Maybe when you face very tough opponents who abuse the judge and also you, the question arises how to what art of advocacy you apply. My suggestion to all, which I have been doing all along, is to laugh it away, so that the belligerent lawyers will stop abusing you at least. Let him abuse the judge. I also feel it is my personal opinion, nothing to do with politics or anything like that. I feel a lawyer should not have politics. He may believe in certain policies outside the court. Inside the court, no politics. He is an officer of the court. If we maintain that distinction between our political philosophy and our role as a lawyer, it takes a person a long way. It is not as if you are not going to lose anything by not exhibiting your political philosophy in courts. I didn't belong to any political party, nor do I belong today. But nevertheless, some of the officers came to me, notwithstanding that, even though I don't belong to any political party. So whatever is you are bound to get by virtue of your merit and ability, you will get it irrespective of the fact that you belong to a particular political party or not. I am reminded of the words of a judge who said, in order to be successful as a lawyer, you must have the constitution of an ox, and you must have the patience of an ass, and I add one more, you must be thick-skinned like a crocodile. Thank you very much for giving me the opportunity.
Our senior said two things about the art of advocacy. One is begging, then rebellious. One more thing I would like to add is confuse the judge. I would like to add one example from our senior. My senior was about to leave by 4 o'clock. He was sitting in the chamber, and the next man was called before His Lordship A.R. Lakshman and Justice Raju, both before becoming judges of Supreme Court. So I went and brought Gandhi, and while walking in the corridor, he said, I'll be in the meeting at Cosmopolitan by 4:45. It was 4 o'clock we were walking in the corridor. I said, how it is possible, sir? I'm going to get the adjournment. No. So he stood up and argued the case for 10 minutes. Both the judges were exchanging the papers, and also at particular point of time, His Lordship Justice Raju said, Mr. Gandhi, you are confusing us. Immediately Gandhi said, that is our job. And after that, it was adjourned. 4:45 he was there in the club. With these few words, I just now. Question and answer.
Yes.
I read a page in the book written by Mr. Harriman. I will quote that passage. He says, the court of Justice Subbarao, then Attorney General Nirende was arguing the case. From nowhere, Justice Subbarao asked him, what do you say about prospective overruling? Nirende felt it was not relevant, but he didn't mince a word, and he kept, that's what he says, he kept in a clipped English, I refuse to argue the prospective overruling. I believe this, as Nariman writes, completely upset Subbarao, and it unsettled him. Thereafter, Nariman has not said whether it is correct or not. I request your response. Would you do that?
I think, speaking for myself, I won't do that. I will not say that I will refuse to answer the question. If I know the subject and if I can answer it, I will answer it on the spot. If I do not know the subject and if I have to equip myself something more, I tell the court that you give me some time to answer your question. I will equip myself and come back to you tomorrow, day after tomorrow. That is how I will do. But to say that I refuse to answer, or the question posed by you is irrelevant. He's not respecting the seat there. Forget about the individuals, Barrow may be right or wrong, but whatever it is, we have to respect the court. Why I say that is the respect which we get from the client depends upon the respect you show to the judges. If you are very, very rough and tough with the judge, and if you disrespect him, the client will mete out the same treatment to you. So I won't do it. I think he is right. My subsequent case will also go away. Now, I am not keeping that in mind, but I am saying respecting the court is more important. That is part of the advocacy. And most of us are not 10th generation lawyers. We built up a practice in the second or third. So our livelihood also depends on the profession. So it is all the more necessary that you should be respect the seat there by the person who is sitting on the seat.
Sriram's father, 5 years old, he said, "Dam case by they go to the dam, then some blacks got up in dam to his house, but cracked. You get that by cracks and then they shot his father. How many blacks are there in your house? First question is
Nugent. You follow the question. How many cracks are there in your house? Apart from
first point is cannabis. Subsequently, going on telling some other points. Go on and say, now make case Odisha. Today, first point cannabis. Going on telling the point. Now the day they will raise someone dismiss. First point. Subsequently, you told all other points revenue. Whatever we start, cannabis is the first point. Let us see.
You are 100% right. In fact, Mr. Ravindran was just talking to me before this meeting, and he was telling me an instance where a matter was listed. We were Justice Bhaktav's, late Justice Bhaktav's, and it was a voluminous brief. He said, "All right, I admit." The lawyer started arguing for some time. Then he called the matter and dismissed the matter.
Super partition. When I advocate, our member argued at the time. First point is the state candidate, you know, but bringing the brothers. Again, some other points he showed. Now we are telling what is the cannabis. Subsequently, now going to discuss. I myself drafted this case. That is why all the parties all the enthusiastically we should not present it.
You are right.
All the biggest points.
You are right.
Any questions from the junior advocates, law students? Please.
Which was found by the court accordingly. So whether the witness will be placed under the provision of the IPC which provides the punishment for giving false information, whether it will be put into such circumstances or not.
You can file an application for perjury before the court, and the court is convinced that there is perjury. Further action will be taken by the court. There is no difficulty.
Thank you, sir. Thank you.
Because everybody knows you're a great senior. Just a few words about your senior Dolia, from whom what you have, just a reminiscence of your senior of that higher Dolia office from the day when you joined in your initial days, and what's that art of advocacy which you owe to your senior, so that this bar always depends on the seniors and we emulate you all. So a memory from your seniors' days will be of great assistance to us.
He is a man who never offended the judges, and he believed very much in the courts and justice. And he always taught us, even in your reply notice to a lawyer, don't use any strong language. The reason which he gave was very laudable. He said if the court subsequently goes through your reply, they may get prejudiced. Why such strong language has been used? So never use any strong language. And to the best of my knowledge, he never offended any judge. And he will try to put forth his best of points. And he was a successful lawyer. You can imagine a man coming from first generation lawyer who comes from Gujarat, not knowing the regional language and building up a practice on all sides. He had worked from small class court up to Supreme Court. Conveyancing was there. All branches of law, ask anything, it was there. It is on account of my work in that office, whatever little I know, I owe to Mr. Doria. In fact, Mr. Doria used to prepare very complicated conveyancing documents. Many people may be under the impression that he was a labor lawyer. No doubt, he specialized in labor law. But when I went to him on the first day to join in the office as an apprentice, I was the last batch. Myself and our ASG's father, we were in the same batch. We had the apprenticeship program. We had to undergo apprenticeship for 1 year or 9 months, something like that. Then we had to write an examination. So first day he dictated to me a pari passu agreement. But for that office, I wouldn't have known how to draft a promissory note even. And I wouldn't have known how to draft very complicated documents. And I wouldn't have known what a consolidation is or what a marshalling is in Transfer of Property Act. Everything I learned from him. He never took any class. It is by mere observing him that I learned. I think I absorbed only 1% of his 100%.
Now I request J.H. Dolia to put a shawl on the today's speaker. Now I request A.R.Somayaji, additional source in order to give a memento to the speaker. Now I request Senior Counsel Manishankar to put a shawl on Om Prakash, Senior Counsel Secretary of the Tamil Nadu Senior Appeals Forum. Now I request VP Sindhu, Senior Counsel, to give a memento to the Secretary. Now the vote of thanks to the Secretary. On behalf of the Tamil Nadu Senior Appeals Forum, Shri A.R.Somayaji, President, additional sources to give a memento to the present speaker today.
Today, we are all very lucky because we all know that an erudite person with lot of arguing skill and drafting skill and is known for his appearance in various courts has exchanges views and experience amongst us. Really, we are all very happy, sir, that a most successful career person and with erudite knowledge in all fields has exchanges. And secondly, nobody could have seen him rebellious in any court. That he probably emulated from senior. He said that the senior was never rebellious and used to be very persuasive. But still, even if we are persuasive, we can still forceful. That is art of advocacy. Many people think that we have to be very rebellious, forceful, then only we get an order. But the smiling face used to get a lot of orders and is the most sought after senior. So we are very thankful for your exchanging your views, sir. And I thank Mr. Om Prakash for having taken so much of pain and efforts for organizing lectures here. And also the other convener and the great effort taken by Somayaji sir for this senior forum thing. And all the members for having come and given grace this occasion. And again we will conduct more such lectures in future also. Please do attend and make use of it. Thank you, one and all. And I also thank Arvind Ghosh and Shiva Shanmugam for the useful coordination throughout this series. Thank you very much.